So what happens when a government agency gets it wrong? I mean, when a decision that really affects your life, your business, or your family is just based on a flawed take on the law. Well, in Canada, we have a whole system for that. And you know what? A recent Supreme Court case pretty much rewrote the entire rulebook. Let's dive in.
Just imagine this for a second. You've been denied a disability benefit that you absolutely need. Or maybe your small business was refused a critical license and you can't operate without it. It just feels wrong, maybe even illegal. So what can you actually do? This isn't just some abstract legal question. It's about the fundamental checks and balances we have on government power.
Okay, so you basically have two main paths you can go down: appeal and judicial review. And honestly, they are not the same thing. Think of it like this. An appeal is kind of like getting a second opinion from another doctor who can re-examine you from scratch and maybe come to a completely different conclusion. Judicial review, on the other hand, is more like asking a hospital administrator to check if that first doctor followed all the proper procedures. It's not about the diagnosis itself, it's about whether the process was legal and fair. And this whole situation sets up this fundamental tension in our democracy. Really, you can think of it as a constant constitutional tug of war. In one corner, you've got the courts, acting as the guardians of the law, and in the other corner, you have the government agencies, the experts in their specific fields, everything from immigration to environmental protection. So the huge question is, who gets the final say?
Well, the courts have this kind of superpower called inherent jurisdiction. The best way to think about it is like a built-in safety feature in our legal system. It's not something the government can just give or take away. It's the court's core constitutional authority to make sure that everyone, and that includes the government itself, is playing by the rules.
Now, on the other side of that tug of war, the government has its own tool, something called a privative clause. It's basically like a do not disturb sign that the government tries to hang on the door of its expert agencies. They're trying to say, hey, courts, we've got this. Our experts made the final calls, so you don't need to get involved. But as we're about to see, that sign, well, it doesn't always work.
And this is exactly where the Supreme Court drew a line in the sand. In this huge case, Vavilov, they essentially said, hold on a minute. This quote makes it crystal clear. While the government can try to protect its agencies, it can't just build an impenetrable fortress around them. The courts will always have a key to that gate to make sure the rule of law is being followed.
So this brings us to the pivotal moment in this whole story, the 2019 Supreme Court decision in Canada versus Vavilov. For decades, the law in this area was a complete mess of confusing tests and exceptions. Vavilov was the court's bold attempt to just cut through all of that chaos and create a new, much simpler framework. This timeline really shows you the long and winding road we took to get here. Before 2008, courts were using this thing called the pragmatic and functional test, which is a mouthful, and trust me, the test itself was notoriously complex. Then, in 2008, the Dunsmuir case tried to clean things up, but a lot of people felt it was like putting a Band-Aid on a broken leg. It just didn't fix the underlying confusion. And then, finally, in 2019, Vavilov came along and basically performed major surgery, giving us the streamlined system we have today.
So, what was the single biggest change to come out of Vavilov? The whole script got flipped. The new starting point, the new default position for a court, is now reasonableness. And this is a huge shift. It signals that courts now have to start with the assumption that they should respect the expertise and the role of the people who made that original decision.
All right, so we know reasonableness is the new default, but what in the world does that word actually mean when a judge is looking at a case? What does a reasonable decision even look like? Let's break that down.
This right here is a fundamental shift in perspective. Think of the difference between a referee and a coach. A coach is totally focused on winning the game. A referee, on the other hand, is just focused on making sure the game is played fairly. Well, under this reasonableness standard, the court is acting like a referee, not a coach. They aren't there to second-guess the plays or sub in their own strategy. They're just there to make sure the decision-maker followed the rules and made a justifiable call.
So how does the court actually play referee? Well, it asks a bunch of probing questions about the decision. Does the reasoning actually make sense on its own terms? Or is it full of contradictions? Is the outcome based on the real facts in the law, or does it seem like it was just pulled out of thin air? And crucially, something that was emphasized in older cases like Baker, did the tribunal think about the real-world impact, and did they listen to the people who would be most affected? A no on any of these can lead to a decision being called unreasonable. Now, while reasonableness is the new default, it's not a free-for-all. There are some very specific situations where the courts take off their referee hats and put on their judges' robes. These are the really important exceptions to the rule, where deference is just not the name of the game. For these exceptional cases, there's no room for debate. There's no range of acceptable outcomes. There is only one single right answer, and the court is there to make sure that's what we get. This is what we call the correctness standard, and it only applies to the most fundamental questions that our entire legal system is built on.
So when exactly do courts step in and demand that single correct answer? Vavilov laid out two main triggers. The first one is pretty straightforward. It's when the law itself says so. If a statute gives you a right of appeal, the court will check for correctness, plain and simple. The second trigger is for the really big-ticket items in our legal system: constitutional questions, major legal issues that affect everyone, and of course disputes about which government body even had the power to make the decision in the first place.
Okay, so after all this legal jargon, why does this distinction between reasonableness and correctness actually matter to you and me? Because this framework isn't just some abstract theory for lawyers. It's the core mechanism that balances the huge power of the government with the fundamental rights of every individual.
This table gives us a fantastic snapshot of the two sides of the coin here. On one side, you've got the deference and the flexibility of the reasonableness standard, which is now the norm. And on the other, you have the strict, unwavering correctness standard for those rare but super important exceptions. This is the delicate balance that the entire Vavilov framework is trying to achieve.
At the end of the day, the Vavilov framework is really all about trying to get the best of both worlds. It respects the experts in government who have to make thousands of complex decisions every single day. But it also makes sure that our courts stay as the ultimate guardians, always there to protect the fundamental principles of our democracy.
So, has Vavilov finally created the perfect system? Or is there a danger that, by showing so much deference to government agencies, we might risk slowly chipping away at individual rights over time? It's a critical question that goes right to the heart of what it means to live in a free and democratic society, and it's one that courts and all of us will continue to grapple with.